Well, they've released the full written document. Here it is. Let's read this out. Okay. So it gives the background to the appeals. Not interesting. Then the first thing it does is it talks about Canterbury. Application was brought over a year out of time. The appellant had not previously disputed the finding or sentence imposed at Canterbury Crown Court. So basically they didn't allow the appeal from Canterbury. There was no merit in the underlying proposal. So that's gone. But Leeds, the application was brought 20 days out of time. The appellant's complaints were that the judge should not have proceeded as quickly as he did, initiating and completing the proceedings that day. No particulars of contempt were put to the appellant, to Tommy, and insufficient mitigation was put forward as a result of the haste. So everything was done far too quickly. That was the claim. Okay, this is the judgment now. The court agrees that the judge should not have commenced the hearing of contempt proceedings that day. Bang. Judge was wrong, exactly as I said many times. Once the appellant had removed the video from Facebook, there was no longer sufficient urgency to justify immediate proceedings. It was a kangaroo court. In those circumstances, it would have been preferable to adjourn, as had happened in Canterbury. No need to do it that day. No need to send Tommy to prison that day. No particulars of the contempt were formulated. No particulars of the contempt were formulated or put to the appellant, i.e. Tommy didn't know what he was being accused of, because the judge never watched the whole stream, because the whole thing happened faster than the length of the stream. There was a muddle over the nature of the contempt being considered. In both, the short explanation given by the judge of the general nature of the alleged contempt and the sentencing remarks, there was a reference to matters that could not be a breach of section 4.2 order. Basically, the judge was wrong. The failure to follow part 48 of the criminal process was more than technical, i.e. was not a technical problem. The judge was he didn't follow procedures. Everything he did was wrong. Everything he did was wrong. There was no clarity about what the appellant was admitting or on what basis he was being sentenced. The only reason they pulled Tommy in was because all of the previous things that had gone up, the Canterbury judgment, being singled out in Darren Osborne, his massive years of bad press, all of that was in the head of the judge, was prejudicially in the head of this judge in Leeds. Can Tommy sue? I don't know. I hope so. Finally, further difficulties arose from the limited opportunity that counsel had to investigate mitigation. Yeah, Tommy didn't get a proper lawyer. There was little else which counsel could have done within the constraints under which he was working. The level of detail which could be provided to the court was very limited, and there was no opportunity to obtain character references. It should not usually occur when a custodial term of considerable length is being imposed. It should not usually occur so quickly after the conduct which is complained of. A sentence of committal to immediate custody had been pronounced within 5 hours of the conduct taking place. Kangaroo court sent him to prison. This is, as far as I can tell, this is devastating for the judge. The order at Leeds Crown Court was also erroneously drawn up to suggest that the appellant had been convicted of a criminal offence rather than having been committed for contempt of court. So his court papers sent him down as if he was a serious criminal instead of a contempt. Errors, as it reads, errors like this have serious consequences upon the classification of prisoners, resulting in the deprivation of privileges and release on licence. In this case, it also resulted in the erroneous imposition of a victim surcharge. The finding of contempt in Leeds is quashed. All consequential orders fall away. The court remits the matter of alleged contempt at Leeds Crown Court to be heard again before a different judge. They've said he can be held, that they'll have to hear the original contempt charge, but against another judge, one who is not obviously an idiot, prejudicial, and desperate to lock Tommy up. As far as I'm concerned, if you're that judge in Leeds, your big boss in the whole country has just told you you are this is huge as far as I can see. Anyway, gotta go. Great news. Thank you. I'm really pleased. I hope I'll be speaking to Tommy later. Thank you to everyone out there who's shared stuff, who's written stuff, who's said stuff, who's done anything to free Tommy, because it worked. It worked. Massive legal team, massive legal effort, huge money has gone into this. And of course, whether Tommy can win that back, can appeal this and sue for costs, for his costs, for quashing what was obviously a massive miscarriage of justice. Massive. As big as any of the others that have sent Tommy to prison. But this time, what's different is his voice was heard all around the world within a few hours. That first weekend when we had everybody in America going crazy made a huge difference, kept him alive, kept him to the point where he gets this. And this is written by the Lord Chief Justice of Great Britain, the United Kingdom. This is the highest judge in the land. So this, coming from him, that there's nowhere else to go. This is like the whole of America's Supreme Court saying the judge in Leeds screwed up. It's making my day. I'm really excited. All right, thanks. Bye-bye.